Okay. Yes, again. Good afternoon. Good afternoon to everybody. Welcome to everybody to this conference. Today, I'm just welcoming all of you as a holder of the Jean Monnet Chair on European Union Environmental Law. For those who already know us, you know that we are organizing a series of activities, sometimes a seminar, other times maybe workshops. We have also organized some congresses, and of course we have some publications that you can find all that information in our webpage. And for today, and actually like a continuum from our last seminar last week, we are we are devoting this afternoon to a very, very interesting issue, the right to a healthy environment. And for that, we welcome very, very warmly Professor David Boyle. Professor Boyle will be now introduced by Professor Alex Peñalver. So just let me thank you very much that you are sharing this afternoon. That for you, it's just 7 in the morning, so sorry for that. But so still another reason to be more and more grateful to you for spending your time with us this afternoon. And just before we start with the seminar, let me give you some warnings that probably all of you already know, just in terms of technical recommendations. Usually, the platform works very well. We had never had any problem with that, but in case that something happens that we cannot just solve immediately, you will all receive an email from the Jean Monnet Chair or from myself with another link to another session, to another virtual room with another platform, which is Teams. This is our plan B. We never had to use our plan B. Just to remember that for the platform to work better, we recommend that you all have your micros switched off during the presentations. And of course, if you have any question during the presentation of Professor Boyle, you may both use the chat to put your question, and then we will take that question on the debate, or Professor Boyd kindly allow us to invite you if you want to interrupt. He might not interrupt. So I mean, if you want to contribute during his presentation, it's that, well, that's fine. So you need to use this icon with the person with the hand raised to ask for the floor. Then we will give you the floor and you could then contribute. Or you can, of course, as I said, use the chat and we'll take the question in the debate. After the presentation of Professor Boyd, we will just open the floor to all our audience, so then you can contribute both via chat or directly using your micro and your camera. We are recording this seminar this afternoon, so just in case that you don't want to be recorded, please remember to switch off your camera at any time, okay? So I think that's all those technical recommendations. Again, thank you very much, Professor Boyd, and now I'm giving the floor to my colleague, Professor Alex Peñalver.
Okay, good evening, everyone, and welcome to this session. First of all, I would like to thank Professor David Boyd very much for accepting to participate in our conference today as the keynote speaker, especially in this circumstance where the difficulties force us to do this session online. We hope, however, that next meeting with Professor David Boyd can be in person in Barcelona. Let me now proceed by introducing our keynote speaker, and it's an honor for me to present him. Professor David R. Boyd is the United Nations Special Rapporteur on Human Rights and the Environment. He was appointed in this important position for a 3-year term commencing August 1st of 2018. He is an associate professor of law, policy and sustainability at the University of British Columbia, jointly appointed at the Institute for Resources, Environment and Sustainability and the School of Public Policy and Global Affairs. Professor David R. Boyd has a PhD in Resources Management on Environmental Studies from UBC, a law degree from the University of Toronto, and a business degree from the University of Alberta. In his career, he pursued the activist path by serving as the executive director of EcoJustice, which is Canada's largest environmental law charity, and appearing before the Supreme Court of Canada. In addition, he is a member of the World Commission on Environmental Law, an expert advisor for the United Nations Harmony with Nature Initiative, and a member of ILO, the Environmental Law Alliance Worldwide, of which I am also a part. Professor David R. Boyd has been working as a special advisor on sustainability for Canadian Prime Minister Paul Martin. He has advised many governments on environmental, constitutional, and human rights policy, and co-chaired Vancouver's effort to become the world's greenest city by 2020. Of course, I cannot list his multiple publications in the area of environmental law now, because there are really too many. Professor Boyd is the author of 9 books and over 100 reports and articles on environmental law and policy, human rights, and constitutional law. Let me just mention some remarkable books, which include The Rights of Nature of 2017, The Optimist Environmentalist of 2015, and this is very important, no? This sense of optimism, and The Environmental Rights Revolution of 2012. And recently, he has written a novel, Thirst for Justice, from last year, which has been qualified as an eco-thriller. As a United Nations Special Rapporteur, he produced high-quality thematic reports on the situation of human rights and the environment. Right to a Healthy Environment of 2018, The Right to Breathe Clean Air of 2019, A Safe Climate, Human Rights and Climate Change of the same year, 2019, Good Practice in Implementing the Right to a Healthy Environment of 2020, Human Rights Depend on Healthy Biosphere of 2020, and recently, Human Rights and the Global Water Crisis. He lives in South Spender, Iceland. I don't know if I telling very correctly the name, in Canada with his partner and their daughter, and loves to run, hike, kayak, and cycle. Professor David R. Boyd is going to speak today about the legal recognition of the right to a healthy environment in the European Union. Thank you very much, Professor David R. Boyd, for being here with us today. You now have the floor.
Well, thank you very much for that generous introduction, Alexander. And I'm going to share my screen now. Let's see how we can go there. Here we go. So yes, I wish that I could join you in Barcelona today. Obviously, because of the pandemic, that's not possible. So I'm joining you from this small island that you can see in the background here on the west coast of Canada, near Vancouver, which is home to the Saut First Nation and also to an endangered species known as the southern resident killer whales. You know, my friends, scientists estimate that there are 100 billion planets in the Milky Way galaxy and more beyond that out in the universe. But despite the best efforts of generations of scientists, there is only one planet we know that supports life, Earth. This beautiful blue-green planet is truly a miracle, chock-a-block full of natural wonders. Now, despite the hubris of some people who are obsessed with humans living on Mars, it is my strong belief and conviction that Earth is the only home humanity will ever know. And yet we take this planet for granted, and we have inflicted cataclysmic harm upon it. When I was born in the 1960s, the human population was 3 billion. We are now almost 8 billion. During my lifetime, the global economy and greenhouse gas emissions have more than tripled. We have created a climate emergency, a diversity crisis, with a million species at risk of extinction, pervasive pollution that causes 10 million premature deaths annually, and a surge in emerging infectious diseases of zoonotic origin, exemplified by this terrible COVID-19 pandemic that we find ourselves in. Ultimately, all human rights depend on a healthy biosphere and a safe climate. Without functioning ecosystems, which in turn depend on healthy biodiversity, there would be no clean air to breathe, no safe water to drink, or any nutritious food to eat. Healthy ecosystems provide us with a renewable supply of things like wood, fiber, food, fish, and other goods. Healthy ecosystems also provide us with services, including regulation of the Earth's climate, filtering of air and water, recycling of nutrients, and mitigating the impact of natural disasters. It's extraordinary to realize that a single teaspoon of healthy soil contains billions of microorganisms, algae, bacteria, fungi, and others that not only feed plants, but protect them from pests and pathogens. So among the human rights that are threatened and violated by this global environmental crisis are the rights to life, health, food, a healthy environment, water, an adequate standard of living, and culture. For example, coastal communities in the tropics, which are no longer protected by healthy mangrove ecosystems, are more likely to suffer deaths from tropical cyclones, threatening the right to life. Decreasing biological diversity increases the risks of crop failure, while the loss of pollinators jeopardizes 75% of crops, which are essential for fulfilling the right to food. For decades, governments have signed treaties and made pledges to tackle climate change and halt the decline of biodiversity, most notably in 1992 with the UN Framework Convention on Climate Change and the UN Convention on Biological Diversity. If we look back over the past 29 years, we see an embarrassing litany of bold rhetoric, timid action, and broken promises. Since 1992, despite the Framework Convention on Climate Change, natural gas use is up over 80%, oil use is up over 30%, and coal use is up almost 70%. Overall, greenhouse gas emissions have risen more than 60%. Now, of course, in the Paris Agreement, nations pledged to hold the increase in global average temperatures to 2 degrees and to strive to maximize the increase at 1.5. Yet we're already at 1.1 degrees, and we are clearly not on track to meet the Paris targets. Similarly, none of the nature-saving targets agreed upon by parties to the UN Biodiversity Convention in 2000 were met by 2010, and none of the Aichi biodiversity targets were achieved by 2020. The fundamental flaw of these international environmental laws, such as the Convention on Biological Diversity, the Framework Convention on Climate Change, and the Paris Agreement, is the complete absence of enforcement mechanisms. States can make these bold commitments, fail to fulfill them, and are rarely held accountable. And that's why scientific warnings have never been more dire or more clear. The Intergovernmental Panel on Climate Change, the Intergovernmental Science Policy Platform on Biodiversity and Ecosystem Services, the indigenous peoples of the world, young people, all are calling for rapid, systemic, and transformative changes to human society in order to address the global environmental crisis. And that, my friends, is why there is such a vital and promising role for human rights. Because in recent centuries, human rights have served as a catalyst for societal transformations, including the abolition of slavery, progress towards equality for women, and the end of apartheid. Rights are being strategically and successfully employed by indigenous people, LGBTQ+ individuals, and persons with disabilities. Now, of course, it's never simple or easy, but there can be no doubt that human rights have sparked positive and transformative changes. When we come to the global environmental crisis, human rights have a vital role to play. And human rights can be used to overcome the weaknesses of international environmental law. In 2019, the Supreme Court of the Netherlands issued the Urgenda decision, ruling that the Dutch government had violated the human rights of its citizens, including the right to life under the European Convention, by failing to take sufficiently ambitious action to reduce greenhouse gas emissions. The court acknowledged the severity of the global climate crisis and ordered the government to make faster, deeper emission cuts. And the Netherlands government has responded by closing coal-fired power plants, by investing billions of euros in renewable energy, putting roofs on the schools, putting solar panels on the roof of all the schools in the Netherlands, lowering speed limits, and more. So we have this basic equation: environmental law plus human rights equals accountability. And climate change cases based on human rights are springing up all over the world. The Torres Strait Islanders have filed a case against Australia with the UN Human Rights Committee, arguing that Australia's terrible record on climate change violates their rights to life, health, and culture. Greta Thunberg and 15 other youths have filed a similar case with the United Nations Committee on the Rights of the Child, again arguing that inadequate climate action violates their rights. And more recently, 6 Portuguese young people have filed a case against 33 states in the European Court of Human Rights. Even more powerful, though, in the context of the planetary environmental emergency, is the emergence and evolution of the right to live in a safe, clean, healthy, and sustainable environment. At the international level, this right was first mentioned in the Stockholm Declaration back in 1972, a political statement that emerged from the world's first global environmental summit. Countries began adding this right to their constitutions in the 1970s. And today, this right enjoys constitutional protection in more than 100 countries. It is found in the environmental laws of more than 100 countries. The right to a healthy environment is part of regional human rights treaties ratified by more than 130 states. So in total, the right to a healthy environment is recognized in law by 156 out of 193 UN member states, or over 80% of UN states. Now, people always ask me, what is the right to a healthy environment? And my answer is that it's a combination of substantive and procedural elements. On the substantive side, it includes clean air, safe and sufficient water, healthy and sustainably produced food, non-toxic environments where people can live, work, study, and play, healthy ecosystems and biodiversity, both on land and in water, and a safe climate. And then the procedural rights include access to information, public participation in decision-making, access to justice with effective remedies. And the interpretation of the right to a healthy environment must be guided by key principles, including non-discrimination, precaution, non-regression, and prevention. And people also ask me, does it really make a difference? And I can tell you that the answer is unequivocally yes. Research demonstrates that the right to a healthy environment has served as a catalyst for stronger environmental laws and policies, improved implementation and enforcement of those laws and policies, increased levels of public participation, and most importantly, improved environmental performance. Studies show that countries recognizing this right have reduced air pollution faster, reduced greenhouse gas emissions more quickly, and enabled a greater proportion of their populations to have access to safe drinking water. I can give you a few examples from around the world. Slovenia, which is a leading advocate of the right to a healthy environment, decided to get serious about recycling a few years ago. And the percentage of waste going to landfill declined from 75% to 7% between 2009 and 2017. Slovenia has also increased national parks and other protected areas to more than 40% of the country. Another example is Costa Rica. Costa Rica is a small country in Latin America with an inspiring story about the power of the right to a healthy environment. Since adding this right to their constitution in 1994, Costa Rica has reversed a decades-long process of deforestation and doubled the amount of forest cover from less than 25% to more than 50%. They have increased the amount of national parks and other protected areas to almost 30%. They've passed laws that prohibit open pit mining and offshore oil and gas development. They get over 98% of their electricity from clean renewable sources, including solar, wind, hydroelectric, and geothermal. And they have a carbon tax, which they use the revenues to pay indigenous peoples and farmers to protect and restore their land. They also plan to be one of the first countries in the world to completely decarbonize their economy. Another country where right to a healthy environment has proven effective is in France, where this right was added to the French Constitution more recently, just in 2004, as part of the Charter for the Environment. This was a catalyst for the world's first law banning fracking, the world's first law ending all uses of the bee-killing neonicotinoid pesticides, and more recently, a law prohibiting France from exporting pesticides to other countries that are not approved for use in France. France is one of the first countries in the world to explicitly recognize that people have a right to breathe clean air and is being held accountable for that obligation in a series of inspiring court cases. Now, it's no coincidence that Costa Rica and France are the co-leaders of the High Ambition Coalition for Nature and People, which is a visionary effort to protect 30% of Earth's land and waters by 2030. And I can continue this world tour. In Croatia, the right to a healthy environment has been a powerful catalyst for the protection of, again, 40% of its land. In Argentina, the right to a healthy environment was used in a really amazing lawsuit back in 2008 that resulted in a Supreme Court decision ordering all three levels of the government in Argentina to clean up and restore the Matanza-Riachuelo watershed and improve living conditions for the poorest people in Buenos Aires. And this picture is an illustration of how a picture can be worth 1,000 words. This young boy is holding the key to a new unit of social housing that his family will be moving into as part of that court order. So for the first time in this boy's life, he will live in a home with running water and electricity. So that is a testament to the power of the right to a healthy environment. In the Philippines, the Supreme Court has issued decisions ending the logging of old growth forests and requiring the cleanup of heavily polluted Manila Bay. In Chile, the Supreme Court has ordered a cleanup of the notorious pollution hotspot known as Puchuncavi Quintero. In Kenya, the right to a healthy environment was used by citizens to stop the construction of a coal-fired power plant, which would have been the first of its kind in East Africa. In Mexico, citizens used the right to a healthy environment to stop a tourism development that would have destroyed a mangrove ecosystem, and the Supreme Court ordered the restoration of that mangrove ecosystem. In Colombia, I met this group of 25 children and youth who filed a lawsuit against their own government, arguing that deforestation in the Amazon violates their constitutional right to a healthy environment. And the Supreme Court of Colombia agreed with them and ordered the government to sit down with the country's leading scientists and these 25 children and youth to negotiate a plan to end deforestation in the Amazon. So that's a court decision that tackles both the nature crisis and the biodiversity crisis. Of course, the right to a healthy environment is not always a magic wand. Last year, the Supreme Court of Norway issued a decision upholding the government's approval of additional offshore oil and gas exploration in the Barents Sea, which is part of the Arctic Ocean. It has not been able to prevent the Bolsonaro government in Brazil from reversing decades of progress in deforestation and industrial pollution. But on the whole, as I have shown, the right to a healthy environment is clearly a catalyst for positive changes. Now, let's talk specifically about the European Union. Europe, of course, has a well-deserved reputation for leadership in both the fields of human rights and environmental protection. Portugal was the first country in the world to include the right to a healthy environment in its constitution in 1976, followed quickly by Spain in 1978. And so it's deeply disappointing and surprising to learn that today, Europe lags behind other regions in recognizing and protecting the right to a safe, clean, healthy, and sustainable environment. The right to a healthy environment is found in the 1981 African Charter on Human and People's Rights. This right is found in the 1988 Protocol to the American Convention on Human Rights, known as the San Salvador Protocol. It's found in the 2004 Arab Charter on Human Rights, and it's found in the 2012 Association of Southeast Asian Nations Declaration on Human Rights. But the European Convention on Human Rights does not include the right to a healthy environment. So Europe is the only region in the world where the primary regional human rights instrument fails to include this fundamental right. In 1999, in an effort to address this gap, the Parliamentary Assembly of the Council of Europe called for the development of a new protocol on the right to a healthy environment to be added to the European Convention on Human Rights. But the Council of Ministers rejected this idea, referring to, quote, certain difficulties, legal and conceptual, end quote. These difficulties were neither identified nor explained, and no protocol was developed. In 2009, the Parliamentary Assembly of the Council of Europe once again called for a new protocol to the European Convention to recognize the right to a healthy environment. And again, the Council of Ministers rejected the idea, this time on the basis that the European human rights system, quote, already indirectly contributes to the protection of the environment through existing convention rights and their interpretation in the evolving case law of the European Court of Human Rights. So here we are in 2021. Last year, again, the President of the Parliamentary Assembly, Mr. Rick Dames, again called upon states to add a new protocol on the right to a healthy environment to the European Convention on Human Rights. So it is true that the European Court on Human Rights has decided many cases involving various environmental issues, and some of those cases have been successful. The court has relied primarily on the right to life, which is Article 2, and the right to private and family life and the home, Article 8. Many cases, however, have failed, and this is in part due to the ongoing failure to recognize the right to a healthy environment. There are several reasons why it is completely inadequate for Europe to rely on the indirect contributions of existing convention rights to address the scope and severity of the global environmental crisis faced by society today. First of all, a right that is essential for life, well-being, and human dignity should be explicitly recognized, as every other region of the world has acknowledged. Second, it is very difficult to provide the necessary scientific and medical evidence to prove that an individual's health problems or premature death were caused by a specific environmental harm. Most diseases are caused by multiple contributing factors. Third, the European Court has clearly and repeatedly stated that there is no right to nature protection in the European Convention. Yet nature protection is an essential element of the right to a healthy environment because human health and well-being depend on healthy ecosystems and biodiversity. In 2017, the Inter-American Court on Human Rights stated that, quote, a healthy environment is a fundamental right for the existence of humankind. The court added that the right to a healthy environment, unlike other rights, protects the components of the environment, such as forests, rivers, and seas. Thus, the right to a healthy environment differs from the environmental content that arises from the protection of other rights, such as the right to life or the right to personal integrity. Recognition of the right to a healthy environment would help to prevent some of the hundreds of thousands of premature deaths caused annually in Europe by air pollution. It would help to reduce the water pollution that impedes access to safe drinking water for millions of people. It would be a catalyst for increasingly urgent and ambitious climate action needed to protect the rights of hundreds of millions of Europeans. Now, because the human brain cannot comprehend these immense statistics, I want to stop for a minute and share an image and a story. This is Ella Kissy de Bras, a beautiful, radiant young child from the United Kingdom. She loved music and swimming, and her dream was to become a pilot. But her life was cut short in 2013 at the age of 9. She lived in a poor and heavily polluted part of London, England, and she suffered from severe asthma. Whenever the air quality really deteriorated in her community, Ella would have a severe asthma attack. She was taken to the emergency room at the local hospital 27 times in 3 years. On February 15th, 2013, she was taken to the hospital and she did not recover. Last year, there was a coroner's inquest into the cause of Ella's death, and the coroner found for the first time in the world that air pollution was a direct cause of a specific person's death. So I urge you, the next time you hear an abstract statistic about millions of people being harmed by environmental degradation, think of Ella Kissy de Bras. People have the right to breathe clean air. We have the solutions for improving air quality, and failing to implement these solutions is not only unconscionable, but a violation of human rights. My friends, it is time for Europe to respond to the global environmental crisis by adding a new protocol on the right to a healthy environment to the European Convention on Human Rights, as the Parliamentary Assembly has recommended, as the President of the Parliamentary Assembly has recommended. And it is also time for Europe to demonstrate leadership by supporting a pioneering United Nations resolution recognizing the right to a healthy environment, as Dunja Mijatovic, the Commissioner for Human Rights of the Council of Europe, has recommended. The good news is that there is unprecedented momentum towards UN recognition of the right to a healthy environment. It comes as a surprise to many people that the United Nations have never recognized the right to a healthy environment. But I'm working with a group of states at the Human Rights Council led by Costa Rica, Fiji, Monaco, the Maldives, Morocco, Slovenia, and Switzerland to bring a resolution to the United Nations to finally recognize this right. In March, at the March session of the Human Rights Council, just last month, 70 states signed a joint resolution supporting this step. Over 1,100 civil society organizations have written to the Human Rights Council demanding urgent action to address this. The UN Secretary General, the High Commissioner for Human Rights, UNICEF, and the UN Environment Program have all called for United Nations recognition of this right. My friends, it has never been needed so badly. In the short term, the goal is universal recognition of the right to a healthy environment through a resolution of the Human Rights Council, followed by a resolution of the General Assembly. These resolutions are not legally binding, so the right should also be incorporated into a legally binding global instrument, such as a third international covenant or the Global Pact on the Environment, which France proposed several years ago. And ultimately, this right should be added to the Universal Declaration of Human Rights. Now, even though they're not legally binding, UN resolutions do make a difference. So, for example, in 2010, the United Nations recognized for the first time the human right to water. And since then, this right has been added to constitutions, incorporated in national laws and policies. It has influenced court decisions, and most importantly, it has sparked greater government action to deliver on the promise. In Botswana in 2011, the Court of Appeal invoked the resolution on the right to water in ordering the government to restore access to drinking water to the indigenous San people. In Paraguay, the resolution accelerated action, which has lifted the percentage of rural people with access to safe drinking water from 50% a decade ago to 99% today. Even here in Canada, a country that once opposed recognition of the right to water, the UN resolution caused a policy reversal. And since 2015, the government of Canada has invested billions of dollars in partnerships with Indigenous peoples to build safe drinking water infrastructure for over 100 communities that suffered under long-term boil water advisories. Now, of course, states must not only recognize, but implement the fundamental human right to live in a healthy environment. That means taking a rights-based approach to tackling climate change, the biodiversity crisis, and toxic pollution. That means shifting away from fossil fuels to renewables as fast as possible. This means respecting the rights of Indigenous peoples to the lands, waters, and wildlife that sustain their cultures while protecting 30% of the world's lands and waters by 2030. This means redirecting the trillions of dollars in harmful subsidies away from fossil fuels, industrial agriculture, and overfishing towards renewables, energy storage, agroecology, and biodiversity conservation. With COVID-19, humanity is paying a terrible price for ignoring scientists' warnings. We must not make the same mistake again. It is not too late to respond to the global environmental crisis, but time is running out. Nature is not a warehouse of natural resources for humans to exploit, but rather a community to which we are so remarkably fortunate to belong. After all, it is scientific reality that we share DNA, the basic building block of life, with every living thing on this planet. Universal recognition of the right to a healthy environment recognizes that our lives, our health, our well-being and dignity depend on the health of nature. If we fail to employ a rights-based approach to protecting the biosphere, future generations will live in an ecologically impoverished world, deprived of nature's vital contributions to human well-being. The world will be ravaged by increasingly frequent pandemics and riven by deepening environmental injustices. But if we place human rights and nature at the heart of sustainable development, humanity could attain a just and sustainable future in which everyone lives happy, healthy, and fulfilling lives in harmony with nature on this beautiful blue-green planet. Thank you very much, and I look forward to your questions.
Thank you very much, Professor David Boyd, for your good presentation. I think that many questions
Àlex, no et sentim bé.
Ara sí?
Ara una mica millor, però fluix.
Val. Thank you very much, Professor David Boyd. It's okay? It's okay now?
Sí.
Okay.
Está bien.
Muy bien. Muchas gracias. Thank you very much for your brilliant presentation. I think many deep questions and issues have been raised about the legal recognition of the right to healthy environment in a global perspective and after in a regional area, in Europe, in the European Union. I think that there are not now any question in the chat. Then I remember that if anybody wants to contribute to the discussion, please use the raise to hand. Okay, there's one question now. Before speaking, and wait for the moderator, and I will give you to speak. And please activate your microphone and camera if you wish. It's better if we can see you always.
and so that the floor can hear your question or what you think. Then there's one first scan
from me.
From Sara García Toledano. Please, Sara García Toledano. It's right. Okay. She says that, hello, it's been a pleasure listening to you. Sarah, if you want to speak directly without the camera, then we can listen to you.
Si no, llegeix la pregunta.
Okay, then I will read the question. Here, very few people know that if citizens see any violation of human rights in their country, in this case, environmental ones, they can write to the United Nations reporter to report the situation. There is an online form to do so, but could you tell us what is the best way to do it? Is there a pattern of extra? What is important to say in such a complaint? What kind of complaints does the reporter study? I think it's about the role of the United Nations special reporter, about human rights and the environment, and how you can help, this kind of situation. And also in Spain, we have received the housing reporter who urged Spain to take measures to stop the systemic violations of housing rights. This is another kind of right, environmental right, housing rights. How do you see the environmental situation in Spain? Will you cheer people who are suffering any violation of their environmental rights to send you these complaints? And thank you very much.
Okay, Sarah, thank you for those multiple questions, and I'll try my best to answer all of them. Yes, there is definitely a communication system. So United Nations Special Rapporteurs, there are approximately 45 of us at this point in time, covering a wide range of human rights issues, which range from human rights in the environment. There's also a special rapporteur on specifically on toxics and hazardous waste. There's one on food, one on the rights to water and sanitation, one on housing, one on culture, one on torture, and again, a wide spectrum. And these are volunteer positions. So this is something that we do as a part-time. In addition, most of us are university professors, but that's a profession that allows us some additional time. So among the important things that we do are country visits. So we do 2 country visits every year. And those are formal missions. So for example, my first 2 country missions were to Fiji, a small Pacific island state. And I went to Fiji because I really want to witness firsthand the impacts of the global climate crisis. And that was a very powerful and emotional visit. I visited a village that had been completely relocated because of the impacts of climate change, one of the first communities in the world that had to be completely relocated. I visited also some urban, peri-urban settlements or informal settlements on the outskirts of the capital of Fiji, where people are living in very, very difficult circumstances. And a lot of those people had been rendered homeless by a tropical cyclone in 2015, Tropical Cyclone Winston, that devastated Fiji and left thousands of people homeless. And then I wanted to visit a country that's a major oil and gas producer as well. So that's why I went to Norway. And Norway, of course, is a fascinating country with an excellent environmental record in many ways in terms of air quality, renewable electricity, but has this kind of paradoxical situation where their great wealth has been generated by exporting oil and gas. So country visits is one thing, but we can only do 2 country visits a year. And so it's important to have this communications process where anyone in the world can send us information about a situation which they believe is violating human rights in their community, their country. And there's an online submission form. And online you can also read so what we do is we receive information from people, we verify that information to the best of our ability, and then we write a letter to the government involved asking them to explain and provide their perspective on the situation. So on my website, which I've put in the chat box, you can find communications that I've sent to governments all over the world, from the United States to Cambodia, to the Philippines, to Colombia. And those communications will result in the country writing a letter back to me explaining the situation. So it's a way to bring attention to the problem. I don't have any quasi-judicial powers. I can't make recommendations. I have no ability to sanction states for violating human rights. But in some cases, that act of shining a spotlight on the situation results in an improvement. So that's the communications process. And often we will collaborate amongst ourselves because there's often human rights situations that implicate the topics of a variety of special rapporteurs. And then in terms of your questions about Spain specifically, I can say that Spain is a beautiful country, but faces the same environmental challenges that all countries in Europe and indeed around the world face. So, you know, Spain, there are areas of Spain where air quality is causing problems for people's health. So there need to be improvements in air quality, particularly in the larger urban regions like Madrid and Barcelona. There are problems in some areas of Spain with access to safe drinking water, particularly in some of communities like migrant workers, Roma communities. I know Spain is making great strides to shift to renewable energy and to close down coal-fired power plants and have a just transition for the coal industry. And I think that Spain is actually at the forefront globally in terms of the actions it's taking to try and achieve that just transition. And so, you know, I am not by any means an expert on Spain's environmental record, but that's some of the key challenges that Spain faces. And I would love other people to jump in and tell me more about some of the challenges that Spain faces. I was in Madrid a couple of years ago for the Conference of the Parties, the 25th Conference of the Parties to the United Nations Framework Convention on Climate Change. And I will say that I walked every day from my hotel to the conference center, which was about a 1-hour walk in each direction. And, you know, the nature of the meetings meant that I was walking during rush hour on my way there and on my way back. And for a person from the west coast of Canada, I found myself with a sore throat, which I attribute to the emissions from the traffic primarily, which are causing poor air quality in Madrid. So that's something that we know the solutions for, but more action needs to be taken in Spain. I hope I've covered at least some of your questions there, Sarah.
Okay.
Yes, you did. Thank you. Y lo siento a vosotros que antes no podía poner el micrófono y la...
No, just
Vale.
si quieres.
Muchas gracias, Sara.
Okay, I think that there are two persons who wants to say something. No, first, Professor Marc Campins, and also later Professor Pau Vilchez.
Okay.
Then Marc Campins, if you want to intervene.
So thank you very much for this nice presentation. I just have a question. I mean, you have been just talking about the Council of Europe and the role of the Parliamentary Assembly, and well, as far as there is no the support from the Council of Ministers, we are still always on this soft law area where everything may happen, but it's not probably enough. But actually, my point was about the European Union. I mean, the European Union, in fact, in terms of the, well, a healthy environment, right, it seems to be still in its infancy, or in a very, very beginning, in the sense, for instance, that any claim before the European Union Court of Justice seems to be blocked by these rules of standing of the European Court of Justice, the European Union Court of Justice, and from jurisdictional issues and whatever. So, and actually, on the other hand, it's probably, well, it's still probably we still need some time to get the European Union ratifying or any of the the human rights, the convention, the Roma Convention, or any of its protocols. So that's not probably, it will not happen immediately. If it ever happens. So I mean, I wanted to know what was your approach to how the European Union deals with this kind of potential right, and this importance or this obstacle that these procedural or the standing rules are usually meaning for all of us. Thank you.
Yeah, I think that, and I expect there are professors in Barcelona who know more about this area of law than I do. But one thing that I think is clear is that, you have now 27 members of the European Union. You have 47 states that are part of the Council of Europe. And I think part of the good news, which I can bring you, is that the European Union politically seems to be, and perhaps it's the departure of the United Kingdom, the European Union now, for example, at the United Nations Human Rights Council, the European Union is very supportive of this proposed resolution to recognize the right to a healthy environment. So that's a very positive signal. And I can tell you that Germany, which previously was not in favor of such a resolution, through concerted efforts of civil society and other states, Germany has changed its position and is now strongly supportive of recognition of the right to a healthy environment. So that's really kind of a breakthrough that's just happened in recent months. So I think in terms of the 27 member states of the European Union, supporting these UN resolutions will be a major step forward towards EU recognition of the right to a healthy environment. The problem, as you know, in terms of the European Convention on Human Rights and adding a new protocol, is that you have this broader group of countries, which includes, and I'm just going to be perfectly frank with you here, which includes Russia, which is not currently favorably disposed towards the right to a healthy environment, despite the fact that it's found in the Russian constitution. I mean, this is something that I've never been able to understand, is how a country that has the right to a healthy environment in its constitution can oppose these, which is obviously legally binding and enforceable in that country, can oppose United Nations resolutions which are not binding or legally enforceable. It seems like a very contradictory position, but that is the problem at the Council of Europe. In terms of the jurisprudence of the EU Court of Justice, I really find that puzzling as well, because it seems very out of line with the Aarhus Convention, which, the overwhelming majority of European nations are parties to the Aarhus Convention, which makes it very clear the rules about access to justice for parties that are for parties to the Aarhus Convention. Those rules, such as standing and the costs rules, other things related to ensuring access to justice, are intended to be liberally and broadly interpreted. So I feel like there's a tension there between the Aarhus Convention and the jurisprudence of the Court of Justice. And I honestly don't know how that gets resolved, except through people continuing. I think it's important for citizens and communities and civil society organizations to just continue to bring cases. I mean, the reality is, when we look back at any major social issue where the courts have played a role, there has not been just one case brought. There have been dozens, and in some cases hundreds of cases that have had to be brought in order to turn society in a new direction. I think of, in the States, the many decades of litigation based on civil rights that was undertaken by the National Association for the Advancement of Colored People. They actually had a litigation strategy that was put together in 1929, and they went to court time and time and time again, losing case after case in the United States before 25 years later, in a case called Brown versus Board of Education, they had a breakthrough at the Supreme Court of the United States, ruling that segregated schooling was a violation of their constitutional rights. So I think in the environmental context, we need to keep bringing these cases until we get that kind of transformative moment where courts will actually shift into a more progressive jurisprudence.
Thank you.
It's a great question, though, Professor. Thank you.
There is another person, Professor Pau de Vilchez from University of Balearic Islands.
If you want to go just, okay, perfect.
Hi, and thank you very much, Professor Boyd, for your excellent presentation. It was really inspiring. I was thinking during your presentation about the Norwegian case and how the absence of right to a healthy environment in the European Convention of Human Rights proved actually to be quite important, because even regarding the interpretation of the constitutional right to a healthy environment, which appears actually in the Norwegian constitution, the court said that the absence of such a right in the European Convention proved very difficult to interpret Article 2 or Article 8 in favor of the plaintiffs. And this brings me to another case also in 2020, the Irish case, Friends of the Irish Environment versus Ireland, in which the Supreme Court said that the right to a healthy environment, which had been previously recognized by the High Court of Ireland, even if it's not written in the Irish Constitution, was too vague. I mean, it was not specific enough, and it was not different enough from other recognized rights like the right to life or the right to health. And I was wondering what your position was regarding this statement by the Supreme Court of Ireland. What could be the answer be to these questions? The fact that it's not specific enough, that it's too vague, and it's not different enough from the right to health or the right to life. Thank you very much.
Yeah, thank you for those questions, and thank you for identifying these two very, very troubling court decisions from last year, both from Norway and from Ireland. And I was actually involved in the Norwegian case. I filed an amicus curiae brief with the Supreme Court of Norway, and I have to say that it was a very disappointing decision. I mean, disappointing both in terms of the outcome, which is, approving ongoing exploration for new oil and gas resources off the coast of Norway, in a world where the International Energy Agency has concluded years ago that we have more oil, gas, and coal than we can possibly burn and stay within the Paris Agreement targets. But this argument that the right to a healthy environment is somehow vague strikes me as a very uncourageous thing for a court to say. And frankly, it's incorrect. If you look at the articulation of any human right in the world, they are articulated in broad and sweeping terms: the right to life, the right to health, the right to food. And yet that has those in the context of all of those other human rights, that has not stopped courts from determining what the substantive content of those rights includes. And so for a court to say, oh, this right to a healthy environment is somehow vague when none of these other human rights are vague, strikes me as simply wrong in law. And also ignorant of the fact that the right to a healthy environment has existed in national constitutions, as I mentioned during my talk, for now upwards of 40 years, dating back to the earliest constitutional mentions in Portugal and Spain. And so there's no justification for saying that the right to a healthy environment is vague or difficult to define. That's the nature of human rights, and that's the job of courts, is to define the parameters of human rights. And so both in the Norwegian case and the Irish case is a little bit easier to understand from a legal perspective, because in Norway, the language of the right to a healthy environment is directly in Article 112 of the Norwegian Constitution. In Ireland, it was a lower court decision that said, the right to life must include. So in Ireland, the Constitution does not mention the right to a healthy environment, but a lower court had ruled that because the environment is so fundamental to human life, that it could be read into the Irish Constitution as an implicit constitutional right. And that, of course, is a decision. Similar decisions to that have been made in, based on my research, over 20 countries around the world, where high courts have found that the right to life, or in Italy's case, the right to life and the right to health, include an implicit constitutional right to a healthy environment. But the Irish Supreme Court, in their decision last year, as you said, determined that the right to a healthy environment was not implicit in the Irish Constitution, and I think that they made that decision, as I've said, for the wrong reasons. You know, saying that it was, first of all, saying that it's too vague to be determined. That's just a cop-out. That's just a lack of judicial courage. But the Irish court also said that there is no real distinction between the right to a healthy environment and other rights like the right to life, and that is simply not true. The experience over the last 40 years demonstrates, as the Inter-American Court of Human Rights has clearly recognized, that the right to a healthy environment is distinct and different from what we call the greening of existing human rights. And the most powerful way that it's different is that the right to a healthy environment includes protection for nature, whereas the right to life, as the European Court of Human Rights has said in the in the case Kirtatos versus Greece, there is no right to nature protection in the European Convention. Now, I think the European Court is actually wrong as well, because the basis for saying that was that, you know, nature doesn't have sufficient impact on human well-being or human health to justify interpreting Articles 2 and 8 to include nature. And in the cases that have been successful at the European Court, applicants have had to prove that pollution or other forms of environmental degradation have a direct impact on their health and well-being. And you can actually prove that in the context of nature as well. There's abundant scientific evidence that we need healthy ecosystems for our health and well-being. So the European Court is wrong on the science, and I think the Irish and Norwegian courts are wrong on the law.
There is one person who wants to speak, but before there were two others who sent by chat questions. First,
Mara Bocaletti, thank you very much for your inspiring presentation. You mentioned the importance of regulatory frameworks with compliance mechanism, how to make them enforceable, and the role of the state, the judge, and the responsibility of the companies to make them a reality. No, it's a question of how to enforce. No, and I would like to add also to this question, to this very interesting question, that you said the complete absence of enforcing mechanisms. No, and then which are the most important tools to enforce human right to environment? It's just a question related with this other one, no? How to enforce, right. No? You were speaking about we have to press, no, go to the courts, no, but it's the court, it's the political ways, parliament ways. Which one are more important, no?
Yes. Yeah. This is a very important and a very broad question. I think that as lawyers and as environmental lawyers, we tend to too often talk about the courts and litigation as the answer to these problems. I actually think that's misleading. I think that the first line of defense is that if people have the right to a healthy environment, that means that states have the obligation to respect, protect, and fulfill that right. And states have that obligation. They have to exercise and fulfill that obligation by passing laws, by enacting policies, by implementing and enforcing those laws and policies. And people, the only times when people need to resort to litigation and going to courts is when the governments are failing to do their job, when they're failing to fulfill their obligations. And in countries like Spain, Canada, other countries where we have the rule of law, that should really be an exceptional circumstance. We should expect our governments to pass, implement, and enforce laws that fulfill their constitutional obligations to protect the human rights of citizens. And only in the extraordinary circumstances where governments fail to do that is litigation necessary to hold them accountable. And then it's absolutely essential that we have pathways and mechanisms and institutions that enable citizens to have open and liberal access to justice to ensure that they can hold governments accountable for their constitutional obligations. So in a number of these climate change cases, the argument has been raised that climate policy is really the job of the government and not the courts. And I agree with that, but only to an extent. That is true, that parliaments and legislatures are primarily responsible for determining and implementing climate-related policies. But when governments are violating the human rights of their citizens through inadequate climate regulations and policies, then it is the fundamental job of the courts to intervene and to hold those governments accountable. So, I think that from an ideal perspective, human rights should enjoy constitutional protection in every country because constitutions are the highest and strongest form of laws. And in many countries around the world, the constitutional recognition of the right to a healthy environment has, and this is what I've been working on for 15 years, it has served as a catalyst for those stronger laws, for improved implementation and enforcement of those laws. But a couple of things here. One is that the wording of the constitutional provision is very important. And so we have the classic case of Spain, which was one of the first countries to recognize the right to a healthy environment in Article 45 of the Spanish Constitution. But the wording of that provision and its location in the Constitution are very weak. And that has undermined the power of the right to a healthy environment in the Spanish context. In other countries such as Colombia and Costa Rica and France, where the wording is very strong, the right to a healthy environment, it has had a much more powerful influence. So that's an important consideration. On the whole, though, these international agreements like the Aarhus Convention on information, on access to information, public participation, and access to justice in environmental matters, the Aarhus Convention has played a very important role in Europe in raising the floor so that in all countries that are parties to the Aarhus Convention, there has been higher standards for access to information, public participation, and access to justice. And so it's really, it's quite encouraging that this week, actually, a new regional agreement will come into force in Latin America and the Caribbean called the Escazú Agreement, which is really patterned after the Aarhus Convention. And these two agreements are focused on the procedural tools to enable citizens to secure their right to a healthy environment. I believe that actually we should have regional agreements of this nature in every region of the world. And in fact, there's African countries are now in the process of becoming parties to the Aarhus Convention. So I feel this is an encouraging development that will assist citizens and communities in being able to ensure that governments do fulfill their human rights obligations in the environmental context. Sorry for such a long answer.
Thank you very much. There's another question from
Carlos Puente Galindo. It's related about the question from Professor Mark Campins, but it focuses on the last decision of the European Court of Justice, which dismissed the Carvalho and others case, also known as the People Climate case, arguing that the 10 families were not individually affected by the EU's climate policies, which they had felt sued against to force the bloc into adopting stricter protection measures. Do you think that this decision makes even more difficult to recognize of a right to a healthy environment in the EU? And thank you for your brilliant presentation.
Bueno, Carlos, muchas gracias por la pregunta. yes, I've read that decision of the European Court of Justice, and again, it's following a line of cases which take a very narrow perspective on standing, a perspective which, in my opinion, is inconsistent, as I said, with the Aarhus Convention, and a position which is really no longer justifiable in the 21st century. I mean, I think we have reached a position where we are living in a global environmental emergency, and for courts to make decisions based on antiquated ideas about, standing for, there's a real disconnect between that very conservative jurisprudence on standing and the urgency and the magnitude of the challenges we face. We have all of the world's expert scientific bodies saying that we need rapid, systemic, and transformative changes in order to address this global environmental crisis. And we have courts making decisions like this, which are refusing to decide a case on the merits because of rules of standing. It doesn't make sense to me. And I don't think it makes it more difficult for the recognition of the right to a healthy environment in the European Union. I think it makes it more important than ever. I think it's greater evidence that we need political change so that this right, this fundamental human right, has legal recognition and will lead to different decisions from our courts. There's also the very first climate case before the European Court of Human Rights right now, Duarte, Agostinho, and others versus Portugal and 32 other states. This is a critically important opportunity for the European Court of Human Rights to make a precedent-setting decision on the impacts of climate change on human rights. Again, with one of my colleagues from the Special Procedures Branch, I'm filing a third-party intervention in this case, urging the European Court of Human Rights to make a progressive decision, not to close the door to climate litigation in the European Union context. And this, but if you look at the jurisprudence of the court, there are a number of hurdles which the applicants are going to have to overcome. Number one, they did not file a case in Portugal, so they have not exhausted their domestic remedies. Of course, they could not file a case in Portugal against 33 different governments. They would have had to file lawsuits in 33 countries, which is not really a realistic expectation. They have to establish that they are victims of climate change pursuant to the jurisprudence of the European Court. You must establish that. Now, the 6 young people in this case have filed evidence that they are directly impacted by climate change. But again, that's a question that the court will have to grapple with. So this case that's currently before the European Court of Human Rights, critically important. It's very encouraging that the court has expedited the process. They're treating this as a very important and urgent matter. And several judges from the court have talked about the nature of this case and how they will be adjudicating this case in a way that is consistent with their existing jurisprudence in environment. So that's a very clear signal from the court to applicants about what they will need to establish.
Okay, sorry.
We've lost the pictures.
Yes, sorry. You can.
Pero yo puedo escucharte todavía.
Sí, no sé qué ha ocurrido ahora. Well, I don't know what happened.
No, yo tampoco.
That never happened before. Sorry.
Es el peligro cuando dicen que nunca se pasan, se pasan.
Yeah. Okay, sorry. So, well, luckily we are at the end of our seminar, but I think there's still a question. So, perdón, Alex.
Yes, I think that Melinda Janke wants to speak, just to say something. It's your time, Melinda.
It seems that, oops.
Maybe she has some problem.
Yeah, just
Hello,
wait.
are you able to hear me?
Yes.
Yes, Melinda, we can.
Okay, so David, first of all, I'd like to say thank you very much for an absolutely stunning presentation, and I've really learned a lot. I'm also delighted you mentioned the Escasa agreement because I was one of the original people that worked on it, and we used some of the some of the laws in Guyana on access to information to inform the debate. But my question is about the right to a healthy environment, and coming back to something that you said about the science. I mean, it's clear that we are in a climate emergency. The safe limit is 350 parts per million for greenhouse gases in the atmosphere. And it would therefore seem to me arguable that to start fossil fuel production now, for a country to begin fossil fuel production, would raise a very strong presumption that this is actually incompatible with the right to a healthy environment, particularly if you take into account the precautionary principle. And I wondered if you had any thoughts about that, and whether, you know, there may be an argument that, well, it's de minimis because it's already, you know, it will be such a small amount, or we're not responsible for the climate emergency, so it's not our issue. I just wondered what your thoughts might be about that.
Yeah, thank you for this question, Melinda. It's actually something I've been grappling with recently. I think it's a tremendously important question. There are a number of low-income nations like Guyana, like Senegal, and others that have are just in the beginning stages of developing oil and gas resources. And this is, you know, it's the last thing the world needs at this point in time, is more countries developing fossil fuels. And so at first blush, my first reaction was these countries should not be doing this. But I reflected on this over a period of time, and it's very troubling to me that we would say that to a country like Guyana or Senegal, that you should not be developing your oil and gas, when countries like Canada, the United States, Norway are continuing to develop and produce oil and gas. So from my perspective, I think we have to have this conversation internationally. We need to phase out the use of fossil fuels, but where is the justice in allowing Norway to become even more wealthy? It's already, by many standards, the wealthiest country in the world. They're continuing to produce oil and gas. Yet you have people in Senegal, one of the poorer countries in the world. Can we really tell Senegal not to produce oil and gas when the world is still using oil and gas? I think we actually need some kind of negotiated agreement that will dramatically decrease production in countries like Norway, Canada, and the United States, and allow some degree of production of oil and gas as we phase out fossil fuels in these other countries. Again, subject to highest possible environmental standards, protection of human rights, etc. But it's not as easy a question as just saying there's a climate emergency, don't let low-income states produce oil and gas, because that, to me, is fundamentally unjust. So that may come as a surprising answer, but I think that for me, people have approached me saying, for example, they're exploring for oil and gas in Namibia, and it's a Canadian company, which is really kind of embarrassing. But how can we say to Namibia, do not explore for oil and gas, when my country, Canada, continues to produce millions of barrels of gas on a daily basis? There's something wrong about that situation.
Yes, thank you very much, David. And I'd like to separately just engage with you on the Guyana situation, but we'll leave that for another time. And I appreciate your comments very much. Thank you.
Yes, please do get in touch, Melinda. I'd love to hear from you. Thank you.
Thank you, Melinda and David, for the answer. And there's another question in the chat from Sofia Roger. First of all, thank you very much for your presentation. It was very encouraging for the future of the right to a healthy environment. But one of the images in your presentation show a map of the globe. A large part of it was in green, which means that many countries, 80% you say, have constitutionally or by the courts or by law recognized this right. But what about much of North America? The question is about North America. I was surprised that it was blank. I understand the court may pronounce about harmful environmental aspects of
less developed countries, such as the case you explained of Buenos Aires. So do you think the US will finally give constitutional status to the right to a healthy environment? And I would like to add, this is you told that it's very important that the right to healthy environment is recognized constitutional level, no? But what is more important, to be recognized right at constitutional level, but to have important tools to enforce, to protect environment?
Okay, so yes, it's true that when you look at a map of the world, you'll see that there are 37 UN member states that do not yet recognize the right to a healthy environment. Half of those 37 countries are actually small island developing states. So I'm in contact with those small island developing states. It's not that they oppose recognition of the right to a healthy environment. They simply they have very limited resources, politically, legally, and they haven't taken the steps, but they are supportive of it. The major countries that do not yet recognize the right to a healthy environment, as you point out in your question, Sophia, are the United States, Canada, China, Japan, Australia, and New Zealand. Those are the major countries that do not yet recognize it. But there is very good news on this as well. That is, last week, a new law was introduced in the Canadian Parliament, which will, for the first time, recognize the right of Canadians to a healthy environment. It's not a constitutional change, it's a legislative change, but it's a very important step forward. Now, of course, it's currently in process, so we can't celebrate yet, but I'm definitely encouraged by that. Now, that's one piece of good news. I think an even bigger piece of good news, there is also a bill in the United States Congress called the Environmental Justice for All Act of 2021. And this bill, if it is passed by the US Congress, will recognize the right of all Americans to clean air, clean water, and a healthy environment. So this is really groundbreaking. We have prospective legislation in two of the biggest countries that have not previously supported recognition of the right to a healthy environment. If Canada and the United States come on board, I think that will just be the momentum to push the United Nations forward, and we will succeed in getting United Nations resolutions on the right to a healthy environment, either this year potentially, or if not this year, then next year. That is certainly something that I'm cautiously optimistic about. Alex, you mentioned what is more important, the Constitution or the tools? I love these questions when they're phrased as either or, because I can say it's not an either or question, it's both. You need to have legal recognition of the right, and you also need to have all of the tools available. And that is why you have, in some African countries like the Central African Republic, the Democratic Republic of the Congo, you have these beautiful words in their constitutions. But do you have effective protection of the right to a healthy environment? Absolutely not, because the tools are not in place. The institutions are not in place. You don't have independent judiciaries. You have corruption. And so you need the legal recognition, you need the rule of law, and you need effective institutions. And you need sort of all of these components in order to have effective protection and fulfillment of the right to a healthy environment. And you need those tools and those institutions and the rule of law for the effective protection of any human rights. The right to a healthy environment is not unique or special in that sense. It's just like any other human right. You can't expect a country to really fulfill that right in the absence of these basic democratic institutions, tools, and mechanisms.
I think that there is no more questions by a chat, but I think that's the question. I would like to know more your opinion. I would like to know more your opinion about European Union. No, you said that the European Union has a positive role in the international arena in order to recognize the right to a healthy environment.
no? But inside European Union, no, we said, no, this case of Carvalho, no, but there are a lot of other cases, no? But European Union inside has another role, a very restrictive role, no? This is like a schizophrenic, no? European Union is like a schizophrenic international organization, no? It's very strong abroad. It's very strong to the states also, but it's very restrictive by itself for the Commission, for the Council, no? What's your opinion about this?
Yeah, it's an interesting observation, Professor, and I think I would agree with you. It is paradoxical, and it's disappointing in a sense. And as I said during my talk, the European Union internationally is regarded as a leader in environmental protection, a leader in human rights, and yet within the European Union, these kind of ancient rules and these ancient customs persist. And so I think that it's really up to the people of Europe to say, look, there is a disconnect here. There's a gap between what we are saying and what we are doing, and we have a responsibility to close that gap, to bring our actions and our words into harmony when it comes to respecting, advocating for, and fulfilling people's right to live in a healthy environment. And I think that this pandemic has really changed everything. But if you recall the way that children and youth were in the streets, hundreds of thousands, millions of children and youth in the streets prior to the pandemic, I really believe that when this horrible pandemic ends, the children and youth will be back in the streets. And I think that pressure will be unstoppable. I think it will be pressure on the governments of Europe, on the European Union, for change like we've never seen before, for an acceleration of the implementation of renewable energy, for an acceleration of all the changes that we know can and should be made, but which have been put off because of powerful interests in society. I think that the pressure from young people, the things that scientists are telling us need to happen, we have no choice. If we want to, fulfill the sustainable development goals, if we want to protect the human rights of the entire human population, we need to make rapid changes. We know what those changes are, and the right to a healthy environment is not a magic wand that we can say abracadabra, bright green future, but it is a powerful tool that we can use to push governments to make those necessary changes.
The question is that there is a legal recognition of human right to environment at European Union level.
The Charter of Fundamental Rights, in the Article 37, it recognized the right to the environment, no, in an objective perspective. No, it's just more to it's more a mandate or dated to the public authorities to protect the environment, but it's in the Charter of Fundamental Rights. No, it's a pity.
Well, I mean, I think, yeah, I don't think many lawyers would agree with you that it is actually a recognition of people's right to a healthy environment. The wording is different. The wording is more like a duty of the governments to protect the environment. And yeah, well, we have seen, in the work that I did studying the constitutions of the world, there's about 100 constitutions that say people have a right to a healthy environment. There's about almost 160 now that say governments have a duty to protect the environment. And the problem is, in some of those constitutions, you don't have the right, but you do have the duty, people don't have the ability to hold governments accountable to the same extent they do when the right is explicitly articulated. And that's why I think it's so important for European nations. I mean, I think I was looking at this last night. Of the 27 EU member states, 15 have the right to a healthy environment in their constitutions. The remainder are parties to the Aarhus Convention, which has the right to a healthy environment in the preamble and Article 1. So, there's work to be done at the national level. There's work to be done at the regional level. even I would say in those 15 nations that do have the right to a healthy environment in the Constitution, changes could be made in some of those countries, including Spain, to make that a stronger, legally enforceable right that will increase its power within society. But ultimately, this is one part of a suite of changes that we need to make in order to achieve a sustainable future.
I don't know if there is any, is there any other question or? You said that Africa is planning to some states from Africa is planning to be a party of Aarhus Convention.
Yes, that process is underway. You can find out more information on the website of the Aarhus Convention, but the Aarhus Convention, as you know, is not limited to European states. There's a number of Asian states that are parties to the Aarhus Convention. It's open to accession by any country in the world. You know, it's kind of ironic. Canada was part of the negotiations of the Aarhus Convention, but when and Canada opposed the inclusion of the right to a healthy environment, and then when the right to a healthy environment was included in the Aarhus Convention, Canada refused to ratify it. So perhaps that will change now that Canada is in the process of recognizing that right. It would be useful for Canada to be part of the Aarhus Convention. But it's encouraging. I think, you know, there's some good incentives for African states to join the Aarhus Convention because they'll gain access to resources that will help them with strengthening of their domestic legal frameworks, strengthening the institutions within their country. So I think it's actually there are definitely some strong benefits from becoming a party to the Aarhus Convention.
Okay. I don't know if there's. I think that I have some problems from my computer in order to be listened.
Tengo que decir muchas gracias y ahora me voy a desayunarme.
Okay. Thank you, Ben. Thank you very much, for to accept, to be here with us. We hope that next time we can meet in person here in Barcelona, and maybe Canada will be part of Aarhus Convention after a new law was passed. And thank you very much also for the audience, for the participation, for the questions, And Mark, I don't know if you want to say something more.
Yes, just to thank you again, Professor Boyd. Thank you very much for this such a rich dialogue and for your kindness to answer to all our questions. I think that covered a lot of different issues. So now we don't want to take more time from you. And of course, we need to have breakfast because it's not our time in that sense. I would just to thank you again for your kindness and for sharing with us our afternoon in such a very, I think it's a very nice and interesting seminar. So thank you very much. And also thank you very much to all our audience. Okay, and just maybe that, well, that you still have, that you have made an extra effort to adjust to our schedule.
No, well, thank you very much for the opportunity to join you today. Muchas gracias por la invitación y buen día.
Muchas gracias. We hope the next time in Barcelona.
La próxima vez en Barcelona, por supuesto, en español también.
Thank you very much, and thank you to all of you. Thank you. Bye.
Thank you.
Gracias. Bye-bye.